and ask you to clarify a point if that's needed. So if you guys have questions, use the Q&A feature. If you say, hey, Mike, ask her to clarify this real quick, I can jump in and do that. Otherwise, Jill, the time is yours.
All right, great. Thank you so much, Mike. I really appreciate it. Thanks everyone for joining us today. Hopefully we can make this a valuable use of your time, and certainly happy to answer any questions. So I'm going to flip us over to PowerPoint presentation if I can sufficiently navigate the Zoom here. Mike, can you see it?
I can, yes.
Okay, excellent. So the webinar today is about deconstructing employment agreements. As Mike mentioned, I'm Jill. I spent the first 14 or so years of my career in private practice with law firms, including Littler Mendelson, where I was a shareholder and practiced exclusively in the area of labor and employment for that international labor and employment boutique firm. I recently made the jump about a year ago to an in-house role where I have one client instead of many clients, but still focusing on employment, and certainly employment agreements are an everyday thing relative to practicing employment law. And so we thought we'd spend some time today just deconstructing employment agreements. I recognize that some of the folks joining today are here because they'd like to learn what an employment agreement is. And then the other end of the spectrum, appreciate that I may have some in-house counsel colleagues or other employment law attorneys. So I'll try to make this as relevant as possible for everybody. But we thought we'd start off the day talking about just sort of an overview of employment agreements, what they look like, what they mean, why you use them. And then the sort of second half of the presentation, take a deeper dive into the specific agreements, and then certain topics within those agreements used at the beginning of the employment relationship, then those used at the end, and then certainly reserve some time for questions afterwards if anyone has any. So without further ado, let's jump right in. So I wanted to start the presentation with just a quick sort of overview of employment agreements for those of you that are just interested in the topic but don't have a ton of background in employment law. Various different jurisdictions have their own approach to employment agreements, and I think that one of the when someone says an employment agreement, you think employment contract, and so something that is given to an employee at the beginning of an employment relationship that sort of outlines the terms of the employment relationship. It's actually not very common in the US. We have a concept called at-will employment in most of our states, where essentially either party can terminate the employment relationship at any time for any cause, so long as it's non-discriminatory. There's no breach of contract for failure to perform. There's really nothing that ties the employee to stay, and similarly, nothing that guarantees that job from the employer end. There is some contract-based work, but it's traditionally not an employment relationship in the US. There's, if you think about the gig economy or independent contractors or consultants, those who are not employees as a technical matter, but do perform services for a company. And a contract is much more common in that scenario, but of course it's not an employment contract at that time because they're not employees. So they will be used to define the terms of the relationship, the pay for services, how long the individual is expected to be performing those services. And so it's pretty prescriptive. There would be a breach of contract opportunity if there was a failure to perform on either end. So different, not an employment agreement, but definitely used in the performing services for an organization context. Our neighbors in Canada have a sort of opposite approach in a lot of ways in an employment law perspective. They take a common law approach to employment. And so absent for just cause, for dismissal, employment is for an indefinite period of time. What that means, I think, sort of first and foremost, if you're thinking at US versus Canada, that we have to provide notice to employees in Canada prior to termination. And if we don't want to provide that notice or can't for some reason, then we have to pay them in lieu of that notice. And so definitely a heightened obligation there from an employer perspective to the employee. The agreements can include your sort of standard terms, which we will talk a lot about today, things like confidentiality, non-solicitation, non-competition. You can also include certain terms in those agreements in Canada that will reinforce specific obligations under common law, or if there's something that's really important to your industry or company or this position itself, those things can also be included in the agreements. And as we go through a couple more examples, you'll see that some jurisdictions get very specific about what can and cannot be included in those agreements. So it's worth paying attention if you are either looking to sign the agreement or looking to put an agreement in place at your organization. So I know I have some friends in Brazil here. Hello. I think Brazil is really interesting from an employment law perspective. They have a ton of regulation relative to the employment relationship. Agreements are not required there, but they are very common. There is significant union presence in Brazil, and so certainly a collective bargaining agreement that would describe the union relationship with the organization and the employees is definitely an employment agreement. The terms within the agreements include, again, some standard terms, but if you think about the work model, what's the expectation for the employee to perform in this position? What are they going to be doing? What are they going to get paid? What's the compensation going to look like? Is there a commission plan? What's the term? Do we intend to have this be an indefinite term, or is this something that we want to put a collar around in terms of time? Can certainly be included. And then something that you'll hear me refer to numerous times today is the concept of covenants, which are confidentiality, trade secret, non-competition, non-solicitation, and again, we'll take a deeper dive on those in a bit. In Mexico, agreements are required. The federal labor law in Mexico requires that employment agreements are in place at every employment relationship. There's no employment at will there. You can only be dismissed if there's cause for dismissal. And in the EU, every employee also must be provided with a document as it's described in the EU, but it is essentially an employment agreement containing information regarding the essential terms of the employment relationship, and specific terms are required there. So just moving back to the US and the types of US employment agreements, there's, again, I think folks typically think of it as the contract at the beginning of an employment relationship, but there's actually all kinds of agreements, both at the beginning of the relationship, during, and at the end of the relationship, that I would consider employment agreements. And so I wanted to just talk through a few of them here with you today. So there are agreements for governing the ownership of intangibles, and this is an area where we're just seeing a lot more activity as technology becomes more prevalent, as automation becomes more prevalent, and businesses are implementing different types of tech within their day-to-day business operations. This is becoming more and more important. So employers are going to want to be assured that their ownership of any of these intangible rights that they have can be protected, and anything that an employee develops while they're employed by the company stays with the company. And so agreements sort of around that nucleus of facts are becoming really, really important. And so we're seeing an uptick in those types of agreements. We're going to talk in a little bit about a proprietary information and invention agreement, which is an extremely popular agreement right now. Some of you may have signed them or reviewed them, and so we will talk about that, but just by way of example. The second type of agreement would be the confidential and proprietary information agreements. This is the more standard agreement that employers have asked their employees to sign for a number of years. It anticipates that there will be developments within the employment relationship while the employee is at the company. They will draft documents, they will build things, they will write code, they will perform their job that will lead to innovation within their particular field. And in doing so, we want to protect, from an employer perspective, that body of work that we've paid the employee for as much as possible. And so that's one piece of it. And then also that while you're in our house, that the employer has some measure of expectation that the employee will keep confidential the things that they learn while they are with that organization and not disclose any confidential information to outside parties or their next employer, for example. There are some restrictions, which I'll try to flag as much as possible, but there is so much nuance here that we could talk all day about the various different jurisdictions, even just in the US, relative to what you can and can't agree with your employee about. Certainly one of the biggest areas is in the agreement not to do something after you're employed with the organization. And again, we will take a deeper dive into things like non-competition and non-solicitation, but just as a flag here, this is one area where you'll want to be mindful of what is and what is not possible. So for example, in California, employees cannot be prohibited from competing with their employer after the employment terminates. So anything that restricts what the individual employee is allowed to do post-termination from employment of that organization is very you want to be very careful about your drafting there. Confidentiality agreements protecting trade secrets and proprietary information are allowed. Again, state laws vary, and certainly specific countries vary on their laws and regulations around these issues. But I think the just sort of number one practice point on that is that you want to make sure that any of these confidentiality or proprietary information agreements are as narrowly tailored as possible so that it doesn't read as though you are trying to restrict everything or keep confidential everything, so as the employee would not be able to, function in another role, irrespective of what the industry is or what that person's doing. And so narrowly tailoring, even by position, can be really important. Certain types of commission agreements are also considered employment agreements. I think that the commission agreements are typically written from the perspective of there will be a challenge, there will be a dispute, and so let's try to guard against that as much as possible. In some states, there is a requirement to have an agreement in writing relative to commission plans or payments, and so again, check the jurisdiction to make sure that there aren't specific requirements or prohibitions. Executive agreements are another really popular type of U.S. agreement. Of course, this would set forth the terms of the employment of an executive or senior executive. It would most often include some type of severance and or benefits that would be available to the executive post employment, and definitely set forth the terms under which the employment would end. If you've heard the term golden parachute, a lot of times that sort of stems from the executive agreement. And the last is an retention agreement, which is generally used to attract and retain employees who might see the employment relationship involving a certain amount of risk, whether that's because it's just for a short term or because the company is in a particular industry where there's risk associated with joining the organization at that time. So, just to give a quick example, an employer might need to have a senior executive come in when the company is failing or ailing, and the expectation would be that that executive would hopefully turn things around from a business perspective. Of course, there's risk in joining a company that is not necessarily thriving, and so making sure that there is some level of security or incentive for that employee to join the organization can be sort of worked out in utilizing a retention agreement. I just wanted to highlight again that state law or individual jurisdictions govern a lot of the details relative to what can and cannot be included in an agreement. And so I'd like to sort of think about the essential terms first when I'm reviewing an agreement or getting ready to draft an agreement. And the essential terms, if you think just general basic contract law, or the payment, the compensation, the term, duration, And then any other of the specifics that would be determinative for the employee in making the decision to join the organization or to sign the agreement. Certain states take the position that if the contract doesn't include those specific terms, then it won't be fully integrated. So if it's missing terms like compensation, duration, position title, description, or duties, then it may or may not even be valid. So again, really important to check the individual state law when looking to implement these types of agreements. There are a couple of discussion points relative to unionized employees here, but collective bargaining agreements are obviously a very important component when we're thinking about employment agreements, as it's sort of one of the fundamental employment agreements that we have that really does set forth the terms and conditions of employment. And of course includes, for those of you who aren't familiar with collective bargaining agreements, it's the instrument that's used for a union environment in order to set forth the expectations of the union on behalf of the employees that it represents with the employer. So the employer and the union will enter into a collective bargaining agreement that, much like the title states, that you bargain for the terms. There's a discussion and a negotiation back and forth to figure out how much folks are going to be paid, what their benefits are going to look like, what portion of the benefits the employer may take on. But it can even go down so far too as who's going to pay for the t-shirts that the employee may be required to wear when they're on site, and any other individual issue that relates to the employment relationship. And so really important employment agreement to the extent that you are in a unionized environment. And certainly there are different intervals that the agreement is renegotiated or rebargained. And there's a whole set of rules situated around when that can be done and can it be done on off cycle. And so we'll have to probably just do another webinar on that topic, but I wanted to flag it because it's certainly relevant and on the topic of employment agreements. I referenced a couple of slides ago at-will employment, but I just wanted to get a bit more specific to the extent that any of you today aren't familiar with the term. And so an at-will employment is basically an employment contract, and not so much of an employment contract. So you join the organization, you are an at-will employee. It's an indefinite period. There's no sort of you'll be an employee here for a year, but the expectation is such that you've applied for a position, we are hiring you for this position. There are certain roles and responsibilities that you will have to adhere to and will be expected to perform as a part of your employment here. And to the extent that the employee at any time feels like this isn't what I want to do, or I get a better job, they're free to leave. And similarly, the employer can say, you're not performing at the level that we expected, or we think we need a different skill set in this role. And so that termination can happen. The termination of the employment relationship can happen at any time without cause and without notice. And so that's really the sort of true definition of at-will employment. Unless, of course, there is a written or oral agreement for a specified term, or one that provides for termination for specific causes. Again, it is possible. It's less prevalent in the U.S., much more prevalent in other jurisdictions. The U.S. is presumed to be terminable at will. There's some executive friction here. We referenced executive agreements earlier. There is some issue associated with senior executives or C-suite folks who traditionally do have some type of contract or agreement. And so very frequently the at-will employment status erodes the higher up in the organization you become. Again, National Labor Relations Board is a cautionary tale for at-will employment, particularly in a unionized environment. So, a couple of interesting things here. I think that I just want to call out that there are certain circumstances where a party may wish to have the duration of the employment contract continue indefinitely. There are individual state laws that will apply to the ability of the employer to do that. So for example, in California, permanent employment is considered employment for a indefinite period, and you can contract with somebody for that. Furthermore, in California, employment contracts for an indefinite term are specifically presumed to be at will, as they are in the rest of the country, which is a little unusual for California that's so heavily regulated, particularly from an employment perspective. But you do want to make sure that you are very specific if you are entering into an agreement, particularly in California, that it could be considered permanent, and therefore you'd have to deal with the unraveling of the agreement in the event that you did wish to terminate the specific relationship. Employment contracts can be for a specified term. Again, individual state laws tell you where, when, how long. Again, just to call it California, a contract for a specific term can be terminated before the agreed upon date. But again, you're going to have to deal with possibility for willful breach. You could terminate the contract early for neglect of duties or particular incapacity to perform. Those become very tricky, particularly in California, to pursue. And so just a word to wise in terms of lose you.
Jill, I lost your slideshow there for a second. It just kicked you out of the slideshow, but we've got you.
Is this, do you see my slides again?
I see your face and not slides. So just hit the share button again there. Just actually, while we have a natural break, if you don't mind for a second, I just want to remind you, some of you guys came in later, and that was by design. Jill here in a minute is going to be transitioning from the 101 stuff to sort of the advanced stuff. As she does that, I'm noticing questions that have to do with some of the things that Jill's going to get to about non-compete clauses, improper termination claims. Keep those questions coming. Jill will do about 30 minutes of talking the advanced stuff, including termination issues, and then we'll get into questions. So in this interim time, as Jill's talking, any questions pop up, drop them in there, and you guys can actually like each other's questions so that we know that those become priorities. Jill, thank you for the totally unplanned pause. Go ahead.
Great. Okay, super. So thank you. Just last thing on this slide relative to the National Relations Labor Board, there have been opinions that have cautioned employers not to use at-will employment language that might suggest that employees can, that their at-will status can never be changed. And so again, as you're drafting these agreements, it's important to be mindful of the industry, I think, is important, but also certainly where the employee is located. And then also ultimately why are you including these terms, right? Is it because you're anticipating a project is only going to last for a period of time? Or do you have a good reason for it? Or these just clauses that you're including because the last one you did perhaps had that clause in it? And so just a quick call out there. So I also think it's important to talk about what kinds of things we can agree upon in the context of an employment agreement. And so probationary periods are one that I think are becoming more and more controversial, but it's, I think, fairly common to have some type of, in a lot of industries in particular, to have a probationary period. So it's sort of like a tryout. Which I think makes sense if you think about when you join an organization, you may or may not have the ability to gain the full picture of both what the organization is like, the individuals you'll be working with, but also thinking about when you join an organization, are you able to do the job, or is this the job that you thought it was going to be? And similarly, from the employer perspective, making sure that your skill set is a match. And so probationary periods, whether or not they're allowed within the agreement, again, depends on the state and in some cases the industry, whether the employee is a part of a union and subject to a collective bargaining agreement. So always something to check. Some states have found that probationary periods are inconsistent with at-will employment. Other employers who use them, I think, in my experience, have found it difficult to assert that sort of post-probation, just past the probationary period, and we're in a place where, like, this is not working out, and how do we unwind it because we sort of already have gone through this, you know, very specific probationary period that is supposed to have allowed that, tryout to occur. And so I think it's something that you want to be, again, including if you think it's particularly important for whatever the employment relationship that you're entering into, but definitely not something that you just use and blanket across all agreements. In terms of the covenants, again, we're going to take a deep dive here, but in most states, not all, you can agree to certain post-employment obligations, non-competition. You're not going to compete with the organization that you're currently employed with if you move on to another organization. Unfair competition, very similarly, and non-solicitation. All of this relates to post-employment activity. So taking what you learned, taking the clients that you developed relationships with, taking the knowledge and moving on to another organization and using it, what you gained from company A, the first employer, to benefit company B. And again, we will talk about those, but I think it's important to note, if you're only going to hang out for the first part of the presentation, that it cannot be, I think probably the most important part of adopting a covenant and employment agreement is making sure it's narrowly tailored. So keeping a collar on the amount of time, 1 year, 2 years, 3 years at the most, geographic scope, being very specific about the scope and thinking, is this person selling tires, for example, and so they could sell tires anywhere, or are they a specialist in a very nuanced area of medicine where they may not be able to go down the street, 10 miles and get another job. And so perhaps a larger geographic scope is appropriate there, but really being very thoughtful about that specific to the position itself. And then also narrowly tailoring the specific prohibited activity. So what is necessary legitimately to protect the interests of the employer. So what we've seen, I think, is a trend from courts is that when they are willing to enforce these restrictions, they're doing so only as it relates to the employee's former job, their specific contacts, the geographic reach that he or she had in that position, the specific exposure to the specific confidential information. And so, there's been, I think, a pretty significant attack on the validity of these covenants in employment agreements generally. And so if you are in a jurisdiction that still allows it, I think it's a best practice. A lot of employers are still utilizing these covenants. But again, if you aren't narrowly tailoring them, they may not, hold up in court. And so certainly something to pay attention to. I think another trend that we're seeing that is probably the largest sort of public knowledge trend here is the fallout from the Me Too movement and the impact that Me Too has had on the ability to include confidentiality clauses or NDAs relative to harassment in the workplace. There's a lot of states who are enacting legislation that prohibits those waiver of claims, and there's a bunch of other, which again, we will talk about shortly, prohibition on waivers of certain rights and ability to pursue certain claims from an SEC perspective when you are entering into certain agreements with your employer. And so that will be coming next. I think just I have a note here that I want to make sure I mention on this slide. The unfair competition lawsuits, these covenants not to compete, non-solicitation for unfair competition, I think have become more and more difficult as technology has made it easier for employees to take the information, to take the customer list, to take the trade secrets, and certainly much harder for employers to guard against that without putting really intentional protocols within their technology to prevent the transfer of data and information. I want to call out that some states have enacted legislation that prohibits these types of covenants and agreements for employees who make below a certain level of compensation or pay. There are certain states who prohibit non-compete agreements for workers who are earning less than $100,000 annually. So for some states, the threshold's pretty high. In Oregon, there's a recent state law enacted that substantially narrows the circumstances under which certain non-compete agreements can be included. California has completely obliterated their non-competition law. There is some measure of non-solicitation governance still alive in California, but that's, I think, probably not long for this world. Texas, Ohio, Georgia, Colorado. I'm not going to take a deep dive, although I did notice there are a couple of folks from Georgia. So just very quickly, Georgia's state legislature has tried on numerous occasions to facilitate enforcement of covenants, restrictive covenants in that state. It had previously been one of the most difficult states to enforce such covenants, but we're actually seeing a little bit of a loosening in that state, so going in the other direction. So definitely a hot area of employment law, and something that you'll want to be mindful if you are enacting or reviewing these agreements. All right, so last part of our Employment Agreement 101 section, and just talking quickly about, as a practical matter, under what circumstances are we going to use an employment agreement? So I think, again, thinking if you joined today thinking we're going to be talking strictly about employment contracts that occur at the beginning of the employment relationship, and traditionally there is some expectation setting that goes on there. You apply for a job and then you are made an offer, and the offer will include, of course, what your compensation will be, but then also any additional benefits that come along with the position, as well as the expectations that you will have in that role. And so it, can also set forth terms of employment, other expectations, things that you might find in an employee handbook relative to confidentiality or anti-harassment, anti-discrimination, different things like that. And so if you don't have an employment agreement per se, you may be given an offer letter that will include a lot of the same types of information, but also the same types of expectation setting with in between the employer and the employee. And so definitely important to sort of start out the employment relationship, whether it's through an agreement or through an offer letter or some other documentation setting forth the terms. Of course, if there's a collective bargaining agreement in a unionized environment, that would also create that structure so that folks can get on the same page as they embark on the employment relationship. Okay. So we're going to move now to the kind of deeper dive on some of these agreements. I broke it up into onboarding agreements and then offboarding or end of employment agreements. I wanted to just talk through a few of the onboarding agreements that I've mentioned before, but want to get a bit more specific relative to what they mean and what context they're used, and then certainly how I review and consider what to add into a specific agreement. So we'll just take them one by one. I thought that it would be helpful just to give you a quick snapshot of, and this is not live, this is my screenshot version of what the Law Insider website looks like. I use it myself and find it to be super helpful when I am trying to determine whether or not I want to include a particular clause in an agreement, first and foremost, but also to get a sense of what types of components within take non-competition agreement, for example, that I want to include. And so if you're not familiar with the platform, it's really easy to run a quick search. It can be non-Boolean, just natural word. You'll see up at the top, I narrowed the filter for specific years because I wanted to make sure I was getting more current or more recent agreements, given the fact that the non-competition space changes so rapidly. So you'll see filing year 2015 to 2020, and then I just threw in a search term of non-competition and it pulled up, looks like 300,000 options, which you can also then add in if, for example, you might add, I might add employer or employee or company or other types of terms to sort of narrow those searches. But I just wanted to give you a sort of quick snapshot of thought process and sort of how I go through these these particular agreements when I'm putting them together. So I pulled again, this is a screenshot from the website, but you can go in and pull various different clauses relative to whatever the topic is. Here we're looking at covenants. And again, I think this is really important because it is one of the, I think, most powerful agreements that you can get from an employee if you're in an area or jurisdiction that allows it. From an employer perspective, it really does, I think, help, not only prevent the type of business impact that it can have if an employee leaves and takes your clients or information to one of your competitors, but I do think it's really powerful in the relationship generally, so that the employee is aware that this is conduct that we, have taken steps to guard against, that we think is important to protect, and that, we wouldn't want to tolerate any type of, competition from our former employees. And so I think it does prohibit or prevent employees from seeking those types of roles with competitors in the first place. And so the litigation fallout from non-competition and non-solicitation can be really challenging and very expensive, but I think this is an instrument that also can help sort of guard against those things happening in the first place. So definitely recommended to the extent that it's possible and legal in whatever jurisdiction you're in. So I think that it's interesting to look quickly at what California has said about non-competitions and why they're unenforceable. And even if you're not in California or operating in California, I think it's relevant because it really does help, I think, make your ability to draft this particular clause in the agreement in a very specific way, so that you're kind of guarding against these attacks on the covenant as you're drafting it. And so California has said any contract by which somebody is restrained from engaging in a lawful profession or trade or business is void. So they are very specific that they do not want to prevent individuals from being able to go out and find another job. And I appreciate that sentiment. I think that when we are drafting these agreements, again, it's really important to make sure that we are being as specific and narrow as possible. Again, use the tire salesman as an example. I think that, you want to talk about what territories that individual worked in specifically. And instead of just saying the East Coast, that you are as specific as possible as you can on the territory. Similarly for time, realistically, I think a year, 2 years, 3 years is the kind of top threshold of for how long can you prevent somebody from engaging in competitive business. And so thinking thoughtfully about what time frame you think you need in order to, if this person were to leave, what can we do as an organization to, within that time frame, make sure that we are doing what we need to do to repair the relationships or build the relationships or guard against the taking of whatever the trade secrets are. And so again, just being very thoughtful about this is really important. There has been extensive litigation relative to trade secrets, whether or not you can include language about trade secrets and sort of what trade secrets really are. And I think the most common example that folks use just for course of discussion is the secret for Coca-Cola, right? So that is a highly guarded secret that no one knows what the actual recipe for Coca-Cola is. And then, sort of other end of the spectrum is maybe information about what the organization does that, maybe you have a description that's maybe a bit more vague, but also on your website that sort of details this is what the company does, or this is how we do a particular thing within our organization. And so you can't really call that a trade secret, even if it's something you developed yourself, if it is out in the ether, available to the public. And so again, something you want to be mindful of when you are drafting these types of clauses in your agreements. Just a quick note on the differences between non-competition and non-solicitation. The non-competition is the agreement not to perform work for a company in competition. Again, define it by scope, define it by industry and time. Non-solicit's a bit different. It's the agreement not to attempt to take, not to solicit work, or what's much more common, employees. So if you leave, you're agreeing that you're not going to call your friends and say, hey, you should come over to this company too, it's great. And again, making sure those provisions are narrowly tailored in scope and time and industry can be extremely important in the efforts to enforce. So non-disclosure agreements, or NDAs, much discussed these days, and whether or not they're valid, whether or not they are protecting against what they are protecting the employee from disclosing. And so again, something that you'll want to be mindful of if you are looking for a non-disclosure agreement. This is just a cut and paste from the Law Insider website. Of course, that is a pretty bare bones NDA in terms of language, but I think is a good snapshot of what an NDA is, what is it protecting. And basically this one is, you're not going to talk about what you learned while you were employed here. And NDAs take all kinds of different forms and scope. And so I think one of the reasons why using Law Insider is so interesting to me is that it really does give you the ability to go in and say, like, okay, what are the different kinds of NDAs that are being used, and in what context are they being used? And how can I then use what I've learned by reviewing the Law Insider website or the agreements that are available there in order to construct an NDA that best suits the needs of my organization. And so it's just a very good resource for that type of compare and contrast. For confidentiality, I think this is one area where it will be interesting to see the impact on the prohibition of including waivers or release of information that traditionally had been sort of very closely held relative to sexual harassment settlements. And so if you, again, follow the Me Too revolution at all, you'll know that there has been a sort of aftershock of that sexual harassment lawsuits that result in a settlement, or sexual harassment complaints that internally result in settlement, there are an ever-evolving number of states and jurisdictions that are prohibiting the requirement that be kept confidential. And so interesting from a employer perspective that oftentimes these agreements, like a mutual separation agreement, which we'll talk about in a bit, are entered into in order to resolve perhaps a conflict. Employer doesn't think it's done anything wrong. Employee doesn't think he or she has done anything wrong, but we can both agree that it's time to part ways. And in doing so, there's an agreement signed. And if that agreement cannot be kept confidential, it's an interesting consideration for an employer as to whether or not there's value in entering into the agreement, paying an amount of consideration to the employee, but not getting in exchange the agreement for, be it confidentiality or other provisions. And so definitely an interesting space to watch. But again, lots of different variations in terms of what confidentiality means, what it is being, what it sort of includes from a scope perspective. And again, I think it's a great opportunity to take a look at the different clauses and what they are imparting upon the employee to keep confidential, and then making sure that you are including a clause that matches what your needs are, but is also very specific about a person's position within the organization. There are certainly some positions within a company that maybe don't have a ton of access to matters within the company that would need to be kept confidential. And so a sort of a confidentiality clause that has less teeth may be appropriate than for somebody, an executive or somebody who's in a role that has direct access. You may want to be mindful that your confidentiality clause may need to be put a little more meat on that bone, so to speak. And so not accepting each and every position and scenario as a one-size-fits-all when it comes to employment agreements, I think is really important. I referenced this before, but the PIIA, the Proprietary Information and Invention Assignment Agreement, is probably one of the more popular, recent, utilized employment agreements. It's really designed to ensure that intellectual property and other proprietary rights, those intangible rights created by employees during the course of their employment, remain the property and assignment of the employer itself. And so, again, this is just a snapshot of a clause pulled from Law Insider, but you can see that it is designed really to just make sure that the employee understands that whatever it is that they develop while they are employed by the organization, they are paid for that work, and therefore that work remains property of the company. The PIIA is interesting because it's sort of a hybrid agreement, in my opinion, and can take on a lot of the same types of obligations for the employee. It can include a lot of the same clauses that you would expect to see in an employment agreement or an offer letter or some other type of contractual agreement. Since you are having the employee sign this particular agreement, it's become a nice vehicle for making sure that you include then, of course, the expectation of confidentiality, but also non-disclosure, non-solicitation, in some cases, again, non-competition, but be careful because those are hotly contested or invalidated in a lot of states. And so you certainly wouldn't want to have it included in that measure because it could, I think, create volatility in the enforcement of the agreement generally if you're in a state that does not blue pencil, which is effectively the willingness of the court to go in and say, okay, this non-competition agreement clause is invalid, but I will enforce the rest of it. There are some states that if there's a portion of the agreement that is in contravention of state law, then the entire agreement will get thrown out. So again, really important to pay attention to jurisdiction. I think that this is something that is becoming, again, more and more prevalent as companies are becoming more innovative or becoming more technologically focused, and it allows them to be very prescriptive about what the expectation is relative to what the employee creates while they are employed. Now, an interesting nuance here is the fact that a lot of tech companies that employ software engineers who utilize open source code, which is extremely common. And so you'll want to be careful if you are asking an engineer to sign a PIIA that it is specific to what the expectation is relative to the use of open source code, because there's a world in which if you are not careful about the way that the agreement is drafted, that the engineer could say, you're preventing me from utilizing open source code as a result of this agreement, and then I can't do my job here. And so, again, being very thoughtful about what positions you're utilizing this information for, what types of responsibilities that the individual employee has, and just making sure, again, that the agreement fits that position can be critical. All right, so moving on to end of employment or offboarding, if you will. There are all kinds of termination provisions. Almost every U.S. state has exceptions to the general rule that an employment can be terminated at will. So there's express or implied contracts to discharge only for cause that comes up in some other contexts where there may be a handbook policy or something in the offer letter. So again, be very careful about what is included that could imply a specific contract that you will only be discharged under certain sets of circumstances. I think a lot of times in employee handbooks, it comes up in a progressive discipline type policy where we say, you will receive a written warning, and then you will receive a verbal warning, and then a written warning, and then a performance improvement plan, and then you will be terminated, and here are the reasons you can be terminated. And it sort of designed to be something that folks are using for performance management, but it can become an implied contract in certain circumstances. So make sure that your documents are cohesive. There are certain public policy arguments prohibiting discharge in particular circumstances in certain states. States vary considerably to the extent they will recognize certain exceptions. There are certain common law claims that are recognized. I think in addition to the three that I've mentioned here, there's a number of longstanding federal statutory limitations that bear worth noting relative to at-will discharges, but we'll have to jump down that rabbit hole another day. One of the things that I think is interesting about end of employment contracts or agreements is the inclusion of a no rehire clause. This is, I think, something that is sometimes overlooked, but is also something that is becoming more and more prevalent in terms of legislative activity. And so I wanted to just call it out here. The no rehire clause, the decision to, at the end of someone's employment, if you're entering into an agreement with them, whether it's a mutual separation agreement or a severance agreement, the fact of the matter is the employment relationship is ending. And so the idea that the individual could at some point be rehired at the organization is something you want to be thoughtful of, because number one, you may want to be explicit that, you know, the circumstances under which perhaps it's a job elimination, that, you know, we no longer needed your skill set at this time, but we really loved having you as an employee and we hope that you'll reapply in the future, and sort of allowing that door to remain open, versus somebody who is leaving the organization under perhaps less than stellar circumstances, and the idea that 3 months from now he or she could apply and come back to the organization and perhaps create the same type of strife that we just eliminated by separating the employment and agreeing to do so under certain terms can be problematic. And of course, having a no rehire clause would allow you to guard against the possibility that they could ever be an employee again at the organization. I think the one other call out on this clause that we've seen some litigation, a fair amount of litigation, you know, over the course of the last few years relative to I left the company, or I was separated from the company, and then I reapplied and I didn't get the job, and there is a failure to hire claim as a result of that, where the former employee says, you're not hiring me because I am a member of a protected class, and certainly ripe for those types of claims if you have an employee who leaves under not so great circumstances and then tries to come back and doesn't get the job. Of course, you know, separate from a scenario where it's not a skills match, or there's other, you know, specific reasons why we didn't hire you for that particular scenario. I do want to call out California, who recently sort of upended this longstanding practice of being able to include no rehire clauses. There was a new law that, again, stemmed from the Me Too movement that was a part of a wave of legislation that was surrounding prohibiting work harassment in the workforce, wherein as of January 1 of this year, no rehire clauses in most circumstances are generally void as a matter of law in California. They can be permitted in certain circumstances where the employer has a good faith belief that the employee engaged in harassment or committed sexual harassment or assault in the workplace. In addition, if the employer has a legitimate non-discriminatory or non-retaliatory reason for termination or refusal to rehire, the employer can still rely on those defenses in the event that there is a failure to hire claim later on. So it's not totally fatal in terms of the options related to employers, but definitely a sort of 180 in terms of the ability to include these types of clauses in your agreement. So again, jurisdiction is super important. Mutual separation agreements, just quickly, you know, this is a really kind of kitchen sink type agreement where You're very open to, from an employer perspective, drafting the agreement to meet your needs. It's used with current employees so that you can create a scenario where there's an amicable separation. It takes all forms. It can be for employees who have been longtime employees, where there's been a shift in what the business needs are. And so you want to provide a sort of softer landing or a bridge for the employee to go and find their next opportunity. It can be used where there's not a skills match. And again, perhaps the person is senior level in the organization, and there's certain circumstances why you might want to provide some compensation to that individual. The key here, of course, is that in that payment, and how it's mutual, is the employer is going to pay some sum of money, which is going to be the consideration for the contract. And in exchange for that, the employee is going to promise not to sue and to release claims against the employer. I did note earlier that there are some prohibitions. The SEC has been very specific on what an employee can release relative to claims against the employer. There are certain provisions where the employee still can bring action against the employer for employment-related claims, but there is a restriction on whether or not the employee can profit from or receive damages relative to those claims. And so we do see, I think, a down tick on folks bringing those types of claims after they sign a mutual agreement with the organization. But they do usually include the additional clauses that we've talked about: confidentiality, non-disparagement, meaning that the employee is going to agree not to be negative or disparaging to the organization or about the organization in the public. No rehire, as we talked about. Mutual reference, usually that the employer agrees just to provide dates of employment and what the position that the individual had while they were employed, and not additional commentary relative to what type of employee the individual was while they were there. The key, I think, that with MSAs, of course, is the release of claims. This is something I pulled from the Law Insider website that was filed as a part of a settlement agreement that was filed with the court. And so this is a bit different than a private agreement entered into with an employee and an employer that will not ever be filed as part of settlement of a lawsuit. But certainly the sentiment is the same. One of the things I just wanted to call out relative to these releases is that you need to be mindful of the age of the employee, because the Older Worker Benefits Protection Act, or the OWBPA, requires a very specific amount of time that an employee, if he or she is over 40, can consider whether or not to sign. So it's 21 days for consideration, and then an additional 7 days after they sign for them to revoke. And they need to be given that full amount of time, although they can decide to sign earlier than the 21 days. If the individual is under 40, they just need to be given reasonable time to consider. So just wanted to call that out quickly. I also wanted to note severance agreements, which can be interchangeable with the term separation agreement. There's no technical term for either one of those, although some companies do distinguish between the two, using a separation agreement for the types of scenarios that I just described, where you have a mutual amicable or attempted amicable separation, versus a severance agreement, meaning a severance package is going to be offered. And those come up in a reduction in force or job elimination scenario. They usually have some component of pay and then also additional benefits, whether it's healthcare or otherwise. Severance packages sometimes offer a working notice period. So we may be notifying you early that your job is going to be eliminated, but you will be given the opportunity to continue working until the particular project is finished, or for a specific period of time after that. All right, so this is the question and answer period, and I'll
perfect. That's perfect. So we're going to pivot to some pretty rapid fire questions for Jill. They're all timed, Jill, just so you know. And on some pretty complex issues. So I hope what you guys will do is continue to interact and engage in the chat area. And also, if you want to participate and contribute, you can go to community@lawinsider.com, send an email to us, and let us know. One other thing that I just wanted to point out real quick before we turn to questions, I had a few questions about the tool, the website, the mystery website that Jill was using to get these contract clauses. That is Law Insider. And because we've been asked so many times, we're going to be doing a product webinar as well to help you guys figure out how people like Jill use the tool to be able to pull these different clauses and debate them and think about them. So Jill, here is what we're going to do. I've got a list of questions. You guys can continue to ask questions and definitely thumb up the questions you like so we know which ones to ask. Some of these things you've covered already, Jill, so if I ask it and you feel like it's asked and answered, you can object all you want. So I'm going to just go down this. So Stephanie Hudson asks, do you have a stance on whether to include arbitration clauses in agreements? It seems to vary based on state, but are there strong reasons to defaulting to including them?
Sure. This is I think, a philosophical question. As much as you can have such a thing in an employment law issue. But I think from an organizational standpoint, you need to consider the risk of, I think, large class action type claims from your employees, depending on the organization size. The vulnerability to class actions, or in California, PAGA actions, has just become so expensive and so prevalent, depending on the activity of the plaintiff's bar in the jurisdiction you're in, that there are a lot of organizations that has for sure become the default, because just for the benefit of the larger group that perhaps haven't had exposure to arbitration agreements, it will force an employee who is bringing a claim against an employer through the arbitration process versus federal or state court litigation. I think that there's a lot of variance in opinion as to whether or not that's appropriate from a blanket perspective, but I do think from my perspective, I look at it as what's the vulnerability to class actions. To the extent it's small, it may or may not be something that you want to consider, as it can be fairly controversial, and certainly something that, arbitration isn't always a walk in the park either. It can, I think, be less expensive than litigation in a lot of cases, but there is a lot, I think, depending on the quality of the arbitrators in the jurisdiction, the accessibility to those arbitrators, and you're going to have to overcome some pushback that there's a sentiment that in arbitration there's a lot of splitting of the baby, and less kind of diving into the issues, given the fact that, the court system is making law and arbitration, it's not. So that's my 30-second take on it.
We've got a question from Ishan, and asks about important components that need to be stated in confidentiality and non-compete, which I think you addressed, but also asked about IP ownership. If we're talking about inventions, ideas that come up, any special considerations you have for those kinds of clauses?
Yeah, that's where I think you really want to look at your PIIA agreements and including the language that is in those. I mean, I think if I had to call out one of the most important agreements from an onboarding of employment, onboarding perspective, the PIIA, if you have any type of IP considerations, intellectual property considerations in your organization, that is absolutely something that you want to make sure you're including. And certainly, again, you can include other provisions if you are hesitant to have your new employee sign, a litany of agreements on their first day, signing away all of their rights. I think it's a good way to accomplish what I think the non-competition agreement tries to accomplish or does accomplish in the places that it's enforceable, where you're really guarding against this employee taking what they learn and using it with a competitor, but you're doing so in a way that is, I think, less offensive from a court enforcement perspective.
We've got another question. This might ask you to flip your perspective a little bit. Lena asks, in a state where non-compete clauses are enforceable, what are an employee's options in seeking employment elsewhere? How do they get out of that?
Yeah, so I think I'll keep my in-house lawyer hat on for a second and just say that I think if you have concerns, if you're an employee and you've signed an agreement and you think that, you want to get a new job and you've identified that company and it may violate an agreement that you've signed, I think approaching the organization and saying, hey, listen, I'm interested in company X, and explaining what it is you're going to do for that company. And, hopefully it's not directly competitive. And to the extent that it isn't, being able to say, I wanted to get ahead of this. I wanted to see if you would release me from the agreement because I'm not going to be selling tires. I'm going to be selling, cars.
Something relevant to tires, right? Yeah.
wrong example to use, but it's not exactly the same, and so the vendors will be different, the customers will be different, the supply chain's different, and really pointing out those nuances, I think, as a practical matter, can be really successful, because employers do not want to have to go through litigation in the same way individual employees don't, because it's expensive and time consuming and it's distraction from the daily business. So I think that as a practical matter, that's how I would approach it. I do think it's important, if you are concerned that there's been you may be violating the agreement, that you get a lawyer involved, because I do think that helps to streamline the discussion, so that kind of everybody can get on the same page as you try to work to resolve it.
So Stephanie asks, and I think you addressed this a bit, suggestions on how to protect against improper termination claims, RE at-will employment, and dismissing someone without cause and without notice. We've talked about how you can do that through the legal documents and using Law Insider to get some examples of that. But I'm seeing in a lot of these cases, it's often emails from managers that don't know, that's what's ending up in court a lot. How do you create a culture of that kind of protectiveness without sort of infringing on relationships?
Yeah, I think communication, and hopefully that's not a trite answer, but making sure that, the expectations of the job are communicated and the responsibilities are communicated, and then at the onset of the employment relationship, and then that discussion continues. I always say that nobody should ever be surprised about the performance evaluation they get at the end of the year. And that's incumbent upon the management and the organization to put that on the shoulders of the managers, to make sure that they're giving live feedback, that they are being specific and explicit when something is wrong or something was not handled well. And putting my litigator hat on, those types of discussions, if they are held verbally, followed up via email, or done via email, they become your paper trail to show that, there were multiple discussions about the disconnect relative to performance here. So when we made the decision to separate, this was, number one, not a surprise, and number two, based upon solid legitimate, non-discriminatory business reasons, and not, some nefarious, discriminatory, or biased reason.
As I always say, it's easier to manage paper than it is to manage people. So make sure that you have that trail. Tally Carter.
It depends on your employment counsel and the advice you're giving, I think.
Everybody get a Jill. Tally Carter asked the question, what distinctions need to be included in an executive or key employee agreement? We had an article in the blog recently about Japanese key executives and their very specific context. If talk to me a little bit about those key employee agreements.
Yep, that's a great question. It's almost like Callie was
in your head.
Is that your wife on the chat?
My wife would never watch anything I do that has to do with legal stuff. Go on.
Fair enough. Yeah, so I think that it's actually one of my favorite or best uses of the platform and as a resource, because it really, when you're thinking about, okay, I need an executive agreement, I don't have one, or I'm not convinced the one that I have is in its best form, what else should I have in it? And you could ask a lawyer, you could hire an outside counsel for that for sure. But you could also go on Law Insider and review tens, sometimes hundreds of thousands of agreements and really get a sense of, okay, so here's an executive agreement for somebody at Pepsi. And so I understand what, is going on in that type of industry, but I don't want Pepsi per se. I want, Goodyear tires, or I want the restaurant industry, or I want the, hospitality, fashion industry, whatever it is. And so then you can get a sense of what your colleagues and peers are including. And then also what types of specific provisions are relevant or becoming the sort of expected, particularly in executive agreements where, somebody came up with the idea that we were going to start paying for executives' cars, and then all of a sudden that was a standard term. And so you can get a sense of what perhaps the expectations might be as well.
Yeah, I think this audience, what we've seen is that a bunch of you are working with up and coming companies. And so Law Insider is great for that context, because what's normal to Jill at PayPal is not normal to, the company in Montana that you're advising that just broke $2 million, right?
Yeah.
Carrie Cummings asked, this is specific to California, when are commissions considered earned in California? Are employment agreements that say earned when paid enforceable?
That's a tough one. So that's something you really need to look at the commission plan that will govern. So that's a call me later too specific to answer without seeing the document itself. But you're right to look at the agreement itself in order to determine whether or not that would be when it would be paid.
Call your lawyer, people. Eric and Ihsan both ask us.
I used that card.
Ask a similar question. Eric asked, even though they should be distinct, I've seen non-competition covenants essentially disguised as non-solicitation covenants. Can you comment on that?
Tricky. Yeah, I mean, it's for sure happening, because I think particularly in industries like sales, where there's a traditional, very heavy reliance on non-competition clauses to prevent from, Joe tire salesman leaving Goodyear and going to, what's another tire company?
Firestone.
Okay, sorry for anybody from tire companies who's trying to, it's a risk, right? Because in a lot of scenarios, your sales folks are there to develop really close, tight relationships with your clients. So you create loyalty, and then when that person leaves, they always say you hire the lawyer, not the firm. And very similarly, tire is all considered equal by some measure. You're going to go with the person. And so I think that there's a lot of effort to put lipstick on non-competition pigs here and make them, disguise them as non-solicit as we can. And, candidly, my take on the PIIA agreements, similarly, I think could be considered this looks like a non-compete. It smells like a non-compete. Is it a non-compete? No, it's a PIIA. And so there's all kinds of efforts just to basically say, we pay a lot of money to develop our product and our relationships and our client list, and we want to do everything we can to protect them. Now, I think that there's two utilities in these clauses and agreements. There's if I have to go to court over this to protect my business and seek enforcement from a court, is a court going to see through the fact that this is essentially a non-compete with a white sheet over it, right? Where it's this looks like a non-solicit, but it's actually a non-compete. Is a court going to see through it? If you and I can, the judge probably will as well. But I don't think that's the only utility for these covenants. And this, I may be overstating this might be a little bit of a controversial opinion, but I think that by stating in an agreement that the expectation is that, you are not going to take my customer list and go to my direct competitor with it. And I'm going to say that you can't do that for a year. And I'm going to say that you can't do that within a, 500-mile radius of wherever it is you sit, because that's your territory. And I don't care if you go and sell anything else in the automotive industry, but I do not want you to sell performance tires. And so you create like a small enough universe that's important to you and still sort of accomplishing your goal, while not creating a scenario where that person cannot find another job if it turns out they don't like your job or they get offered another better job. That it will create some level of obligation and expectation of the employee to say, hey, I can't come sell performance tires for you, but I know this industry really well, and I can come sell spark plugs.
The
I need to
spark
get off.
plug. I can be the spark plug giant. Well, what's interesting about that, and I had a question that was on my mind, and one, it mirrors something that Myrtle Mila asks. She asks, is it proper for a clinician employee, presumably medical, to require the company to provide them the list of their patients at the end of their employment with the company? I was thinking similarly for lawyers, which is a weird professional context, that, it's been well litigated that law firms don't own clients. And so for the lawyer that's leaving, right, many a small firm has been built on taking clients with you. Do you have any take on how non-solicitation works in those kind of environments? Not sure if that comes up with working at PayPal, but.
Yeah, not applicable as it relates to law firms and lawyers, but for sure applicable in the medical context. I think this is one of the most prevalent industries, sales and medical. Not only because there's patients and relationships of patients, but that expertise is so valuable that they don't want to lose the person. And if they can prevent them from getting a job anywhere else close to their home through a vehicle of non-competition, then, they're just going to stay at your
Creates that
hospital.
leverage so they never leave, right?
Right. So I've never seen the context of like providing a patient list. Perhaps it's maybe more prevalent in certain industries where there's like a repeat customer, which feels crass relative to patient health, but that type of repeat business, I maybe could see that. But I do see a lot where in the context of negotiating these agreements, the health system or hospital may say, okay, so you can't go and work with hospital A, B, and C, and D. And you come back and say, well, D's, so let's trim this list. And so there is this sort of negotiation over who are the competitors. And if I understand the question correctly, it was like sort of the converse, where it was, you're coming to work with me, provide me a list of your patients, or similarly, provide me a list of your clients. I would be really careful about doing that, both because your prior employer may have had you sign an agreement that says you can't, and also because your second employer, your new employer, may have you sign some type of agreement that says, and this is a clause that's common in the PIIA, that you're not going to bring your prior organization's confidential or proprietary information to us, which is sort of the second company's way of guarding against issues associated with the first company saying, hey, you stole our stuff, but you don't want to be afoul of any of the agreements that you
Going to be looped into any of those lawsuits. So Mark, relevant to leverage, asked the question, Mark Adler asked, is it common for a release to be executed by the employee as a precondition to receiving his or her severance prescribed by the employment contract? How do companies maintain that leverage in getting what they want at termination? Is that allowed?
Yeah, so most agreements are drafted just that way, where your separation date will be specific within the agreement, and then within a time frame, 30 days or less, typically, you will receive the severance payment after you sign the agreement. And so that will include the time period that I mentioned for the Older Workers Benefit Protection Act. So if you take the full 21 days to consider, then you'll have the additional 7 days to revoke. And then you'll have that, next pay period or 30-day, whatever it is within the agreement that's prescribed to make that payment. Of course, to the extent that the organization didn't make the payment within the time frame that's prescribed in the agreement, then you could, conceivably have an action against them for breach of contract.
Getting getting back to the beginning, Nola Fleck asked, if you have a signed and accepted offer of employment that includes the passing of a bona fide drug screening as a pre-employment condition, and the candidate does not return calls or communication attempts to confirm that they actually scheduled the testing, so presumably a testing has not happened yet, can you rescind that offer?
Yes.
That is an excellent answer. Yes, Nola is the answer.
And one for what? 10?
One clear answer, right. So Michael Parrott asked, and we talked about this in a previous webinar when we talked about some of the COVID things, but he asked any additional components or terms that should be considered in employment or related agreements that have arisen out of COVID, now that pandemics are foreseeable. It sort of changes some of the stuff that we talked about before about dealing with what wasn't foreseeable.
Yeah. Geez, I mean, this is a really interesting question. I think the first thing that comes to mind is guarding through the recruitment and offer process relative to where the person is located, where they will be working, where you eventually expect them to be in order to work, and sort of making sure that everybody's on the same page as for time frame. And I'm just seeing a lot of questions in these nerdy employment law forums where the job offer is in New York, but the person's with family in Michigan, and the job is remote, and so having them be physically in New York is not that important right now, but setting forth the expectation that at some point we would like you to be in New York, but then also dealing with the tax implications of having somebody start working remotely in Michigan if your company is not already set up for that. So I think that sort of offer recruitment process is probably the first and foremost thing that comes to mind in terms of impact from COVID. But there's definitely, we're going to see a lot of litigation that will stem from it. I think employee complaints are going to, about workplace environments are going to, they already have increased, and I anticipate that happening even more as organizations start to reopen their workplaces. And so providing certain policies or acknowledgments that are, kind of specific to your workplace to make sure that everyone's on the same page in terms of expectations of what that's going to look like, be important. But it's definitely a can of worms that is just starting to slowly open. And I'm not sure that we can really even anticipate the impact yet.
Just cover it right now. Right. And Nancy asks a question also relevant to this crazy moment. She says, if an employee uses the right to remain in the country due to changes in immigration laws, which seems to change every 3 days, visa expiry, et cetera, what obligation does the employer have to continue to employ the individual if the employment contract doesn't say anything about, hey, if you're not able to get your visa?
Yeah, well, certainly to the extent that they don't have the appropriate immigration paperwork in order to continue working, then that's, there's sort of not very much that anybody can do in that scenario. And certainly the person should not continue to work in contravention of, the work rules. So I think that's probably pretty straightforward, but I see maybe this is also where you were headed, a lot of issues where visa applications have been made, but they are in a pending status that is just a world of flux,
Right.
Maybe not to be resolved until, January at the earliest. And so I think in those situations, as the organizations, it's important for the organization to think about how long can they leave an offer open? Can they put an individual on paid leave while they work through the complexities here? But, if they don't have the appropriate paperwork to work, they shouldn't be working. You don't necessarily need to end the employment relationship if you can put them on unpaid leave if you don't need that headcount. But I think it's pretty clear that, ending the employment relationship, even if you leave the door open to say, hey, we hope that, once you have the appropriate paperwork that you'll come back or that you'll apply and we'd love to have you if there's an open position. But it does create a really difficult position for everyone.
Frustrating. So Ronnie Hendricks asks not a question, but says, I use law insider clauses frequently for agreements like this. Thanks, Ronnie. Jill, thank you for being with us. If people want to follow up with you, ask more really deep questions for really nuanced answers, what's the best way to reach out to you and learn more about you?
I'm on LinkedIn, so it's probably the easiest. Feel free to reach out. Thank you so much for your time today. Hope it was helpful. Stay safe.
Absolutely. And you guys remember that we want you guys to contribute as well. There's all kinds of opportunities in the community. We're actually announcing more coming up. Please email community@lawinsider.com if you want to be part of webinars like this. We do them 2 times a month, or on the blog. That's always available. If you've discovered something nerdy you want to share with some nerdy friends, we're your people. So just email community@lawinsider.com, and we'll see you guys in a couple of weeks. Thank you.
Thank you.